My name is Brittany Molstead, and I had the Laura B. case. Since she was a minor, her father and mother, Dr. and Mrs. B., represented her versus the Pleasant Valley Community School District and Mississippi Bend Area Education Agency. This was back in 1998. A little background information. Laura B. was a 10th grader at Pleasant Valley Community School District. She suffered from depression. In the last couple years, in her 9th and 10th grade years, her grades had suffered immensely. Eventually, through many situations that I'll talk about in a minute, she was placed at an out-of-state placement. She eventually returned to a new public school and was then offered special education services. A little bit of the specifics on Laura's case. She first had several incidences at school and at home that resulted in many hospitalizations, several suspensions in school and out of school. She attempted to overdose. As you can see, in 9th grade, she had an attempted overdose. She had 3 suspensions for attendance. She was admitted to Genesis West, which was a hospital, due to threats that she made against her family when there was a gun in the home. And she was then released a day or two later, and there was a school altercation, which she was called names and ended up being suspended. There was then, when she returned to school, a teacher survey that was conducted asking teachers on how they thought that she would be able to finish up the quarter or the semester with passing grades, and the responses were not good. In 10th grade started, she was later, a month later, admitted to Genesis West again for 4 days. She had a 3-day out-of-school suspension because she had alcohol on property in December. She had unexcused absences and then had a notice of a 1-day suspension for those. She was suspended for smoking cigarettes on campus. She was suspended for behavior issues. After her alcohol incident, she was required to go to the Center for Alcohol and Drug Services, which she did for 14 days in order to return to school. She was suspended then for possession of marijuana and tobacco on school property. Later on in March, she was hospitalized again at Genesis West. This was an involuntary situation. She had a pre-expulsion hearing that she then did not attend because she was in the hospital. Her parents chose to get her treated at the Wilson Center in Faribault, Minnesota, which was not the first hospital that was recommended. She was there for quite some time and had a psych evaluation. The Iowa District Court for Scott County found in April of 1996, said that Laura had been suicidal and had a gun in her home, and so she had overdosed on 3 occasions. She had historically been physically and verbally abusive to her immediate family members and had been assaultive toward her peers at school. She was diagnosed with major depressive disorder, severe with possible psychotic features. Related behavioral problems included interpersonal difficulties with parents, problems at school, and acting out behavior, including substance abuse. So the order stated that Laura was to be immediately placed in the Mount Pleasant Mental Health Institute for a complete psychiatric evaluation and appropriate treatment. And the court continued then to allow the family placement at the Wilson Center in Faribault in lieu of the earlier recommended placement. So she did attend the Wilson Academy from March of 96 till June of 96. When they discharged her, the Iowa District Court agreed with the evidence from the doctor that Laura was a fit subject for discharge. But they also suggested that there was a continuation of individual and family therapy. When she returned to the area after her treatment, Pleasant Valley had assembled to a team with the AEA to determine Laura's educational needs for the fall. However, she returned to school at Bettendorf instead, primarily because of the perceived negative attitudes towards her and the perception of Pleasant Valley, that they couldn't provide an appropriate program for her. And so the Bettendorf program then consisted of one-to-one instruction, goals in organization, self-advocacy skills, vocational skills, accommodations, proofreading assistance, individual conferences for progress checks and problem solving, and also counseling by the school psychologist. And in her second year at Bettendorf, which would have been her senior year, her program included a special class with integration. The parents argued that the district had failed to timely identify Laura. So they were requesting reimbursement from the Pleasant Valley School District for the residential treatment costs of over $68,000. Also reimbursement for private psychotherapy, which was over $11,000, and compensatory educational services for 1 to 3 years. The school stated that they were unaware of the problems that Laura was having until long after they occurred. Parents were not forthcoming with what was going on. They claim that discipline and attendance did not rise to an unusual level compared to her same-age peers. They were unaware of the seriousness of the problem due to the lack of the parent communication, even though they said that they had had some communication with the counselor. They said that she was not identified for special ed because the parents never asked. However, the parents also were not aware of their rights. And the school also said that they were uninvolved in the placement decision when she was transferred out of state for placement. So the decision ended up being that for whether the school should have referred Laura for possible special education evaluation and instruction services was yes, they should have, because schools are responsible for identifying students who need special services and should be held responsible for not providing a free and appropriate education. Because of that, they required that compensatory education was provided at the school's expense, and this would go into her college years. The second decision was whether the school is responsible for paying those costs of the psychotherapy. And they determined that no, schools are not responsible for providing medical services by a licensed physician. Sometimes psychotherapy is considered a related service. However, they saw in this instance that the hospital visits to Genesis West were also instigated by issues that were at home and were not due to the educational program. Then as far as the residential treatment facility at Wilson Academy, They said no, the school would not be responsible for paying for that. They're not required to assume the cost of such placement when the residential placement is a response to medical, social, or emotional problems that may be segregated from the learning process. The law talks about the child find process, related services, the responsibility for identification of students, and medical services that are not reimbursable, that are maybe provided by a licensed physician. So my response is that I agree with the decision mostly. I do agree that they were 100% responsible for identifying a student so that she had a free and appropriate public education. As far as the hospital and psychotherapy costs, if those were being provided by a licensed physician, then I agree that they should not have been paid. As far as the psychotherapy goes, because it could be a related service, and also with the placement, because a placement could, in some instances, be provided by a school district in the instance that it was interfering with the educational process, which I think in this case, her behavior was definitely interfering with her education. The school could have been responsible for this. However, the reason why I agree with their findings in this situation is because there was a very large gap in communication with the school and with the parents. So the school was not nearly aware as they should have been about the situation, and they didn't have those sit-down conversations about placement. Again, all would have probably been different had they evaluated her and identified her in the first place. Implications for this, I would say that first and foremost, knowing under what circumstances the school should begin the evaluation process, knowing what falls under suspecting a disability, when you have all of those red flags popping up, at what point do you need to look at evaluation? 2, I would say clear communication with the parents and among staff is a must, knowing what's going on with the kids. And I think as an administrator, being willing to ask those hard questions and really care about the student, talking to the parents when she's been gone or when she's been hospitalized and asking why that happened, and really getting down to it. Maybe had they tried to open that door of conversation, they would have had a different relationship. And then third, I think having a process in place for your at-risk kids is critical. You know, I wonder what all did the counselor actually know in this situation? Was that being communicated to administrators? Should there have been more knowledge of what was going on, and who dropped the ball on that? But then when that is being communicated to the school, what are we doing for those kids? What are we doing for those kids that are consistently failing, that are consistently missing school, that are consistently being suspended for things? Having that process in place, I think, is really, really important. And last, these are my questions. What are red flags at your school that may warrant further investigation of a student needing special education services? 2, what have you noticed about communication regarding sensitive and sometimes confidential information in your schools? Is that something that has hindered your ability to move forward with a kid, or has that been a positive thing? And third, what programs do you have available for at-risk students, and what does that look like in your schools?